Good afternoon, everybody tuning in from New York and otherwise on the East Coast, and for all of you elsewhere, good day to you. And I am thrilled to be with you as we cross into August. Less thrilled that it is 86 and super humid here in New York City, but that comes with the territory in August. What I am excited about is that we have a great program for all of you that I'll walk you through in just a moment. And if Kathy, you could advance to the next slide, please, I'll do that. Today, we are fortunate to have 4 different attorneys with us from the downstate offices, 3 who are my neighbors here in New York City. And we have a new participant on the webinar, Lauren Schnitzer. I'll introduce Lauren in a minute, with us from our Melville office. So I'm going to start things off as I am doing presently, and in a moment, I'll turn it over, to Paige. Let me just remind you that Paige Carey has been on the webinar a number of times over, and Paige has been tracking what has been exciting and new in the environment of collegiate athletics, as relating to collegiate athletes. There are updates there, potentially a major settlement that could really shake things up. And so Paige is here to tell us about it. I mentioned Lauren. Lauren is a senior counsel who focuses on school law, who with several other attorneys joined our firm at the beginning of the year to bolster our practice on the eastern end of Long Island in that regard. And we're thrilled to have Lauren with us to talk about 2 issues in New York City schools. First, safety reforms that have been adopted, and then burgeoning conversation around whether cell phones make sense to have in schools. Michaela Mancini, who has been with our New York City office for some time, and before that sat with us in Syracuse, is here to present on Title IX. There are some interesting ripples in that space that we want to make sure all of you are aware of. Michaela is back on the program, and we're delighted to have her. Lance Willoughby Hudson, whose office is right through the wall, adjacent to mine, is on the program himself once more. He's been a regular recently. And Lance is going to tackle a question that came in from the audience around dress codes. Essentially, what is it that is changing in the vein of dress codes in terms of policy, in terms of standards, in terms of the law? And there's a lot to digest there, and we expect that it'll be interesting for you to think about those issues, particularly in a post-pandemic workplace. So with that, let me turn to our first speaker, who, as noted, is Paige Carey. Paige is also in the New York City office, as I mentioned, and is here to discuss what are major changes potentially afoot with regard to college athletes and intercollegiate athletics generally. Let's hear about the settlement proposal, because it is definitely worth everyone's time. And Paige, you've been covering this so well for us. Thank you for coming back on to provide the next iteration of this ongoing saga. We appreciate it.
Thank you so much, Gabe. And good afternoon, everyone. Really excited to dive into this new update and this revolutionary, so it's been called, settlement proposal that is truly set to transform college athletics. And just as a brief overview of kind of the schedule of my presentation, what we're going to go over is just a bit of context and some background behind this proposal. And then we'll go ahead and outline the settlement and what it entails, and then talk a little bit about its impact, what's next, and some collateral issues. Next slide, please. So as a bit of background and just some context, really the core of this settlement, it goes all the way back to 2021 in the Supreme Court's Alston decision, which, as a broad overview, held that NCAA rules limiting education-related compensation or benefits were in violation of antitrust law. And in his concurrence, Justice Kavanaugh took this holding even a step further and indicated that the NCAA's remaining compensation rules may also violate antitrust law. So in the aftermath of this 2021 decision, we have seen additional challenges to NCAA rules surrounding student athlete compensation. And this brings us to the case that really is the starter of the settlement, House versus NCAA. And as a bit of background on this case, House was filed by a former Division I swimmer and women's basketball player who overall, as a brief overview, assert that the NCAA rules prohibiting college athletes from receiving anything of value in exchange for the commercial use of their name, image, and likeness violated antitrust law. And ultimately, House was consolidated with two other cases, which involve similar claims brought by student athletes against the NCAA. And these cases are Hubbard versus the NCAA and Carter versus the NCAA. Next slide, please. So this brings us to the most recent update in this area. On July 26, 2024, so I believe that was a little over a week ago. Time's going by really fast, but the settlement documents were filed in the Northern District Court of California to resolve House, Hubbard, and Carter. And the settlement is quite massive. It provides for nearly $2.8 billion in damages, as well as injunctive relief for student athletes. Really, the relief in this settlement can be broken down into three categories, which I'll discuss. So the first is back pay damages for name, image, and likeness claims. The second is increased benefits from institutions for college athletes going forward. And the third is the elimination of scholarship limits and the establishment of roster limits to replace scholarship limits. Next slide, please. So the first and really the highlight of this settlement is the back pay portion. So as I mentioned, the settlement provides for nearly $2.8 billion in damages, which will be paid to classes of athletes that have been deprived of name, image, and likeness opportunities from around 2016 to present. And all athletes who played Division I sports during this time period are eligible to receive some of this money, but the amount of the money owed to each individual athlete will depend on their market value. And this takes into consideration a variety of different factors and is still a little in flux, but namely, it will depend on the sport that the athlete played and their potential for earning during their time as a student athlete. So it'll be calculated based on a formula. And the back pay will be paid over the course of 10 years on an annual basis beginning in 2025. So it will be incremental to student athletes that are provided with this back pay. Next slide, please. The settlement also increases a variety of benefits for college athletes going forward. Specifically, it allows for Division I schools to provide athletes with direct benefits worth up to 22% of the Power 5 schools' average athletic revenues each year. So these revenues, they are ticket sales, broadcasting revenues, those sorts of revenues. And this is a really huge development because there's never been a option for schools to directly pay student athletes before. So this is quite new and really revolutionary. There's no requirement for Division I schools to participate in this model, but the option is available to all D1 institutions, although it does really focus on the Power 5 conferences, primarily because of that broadcasting revenue, and it's really focused on those Power 5 conferences. So just a couple of key highlights on this revenue sharing model. Like I mentioned, institutions can pay student athletes directly for their name, image, and likeness under this model. It's also notable that third parties can continue to enter into name, image, and likeness agreements with student athletes under this model. However, these agreements will be subject to review to ensure that they're legitimate, providing fair market value, and not being used for pay-for-play. The settlement also allows the NCAA to implement some name, image, and likeness restrictions without fear of participating parties suing them on antitrust grounds in the future. And this goes for, I believe it's 10 years. So 10 years of no ability to sue on antitrust grounds. And the establishment of a clearinghouse for name, image, and likeness payments over $600 is one example of how the NCAA can implement some NIL restrictions under this agreement. So that clearinghouse has been incorporated into this agreement. And significantly, these new benefits may allow for student athletes to receive $1.5 to about $2 billion in new benefits annually, which is quite a large development and really a quite new area of earning for student athletes and a big shift in the model going forward. Next slide, please. Lastly, the settlement agreement modifies NCAA rules to eliminate all scholarship limits and instead implement roster limits. This provides institutions with discretion to offer either partial or full scholarships above the number that's currently permitted by NCAA rules, which caps scholarships currently. But they do have to remain within roster limits. So that's where that roster limit new standard will come in. And really, overall, the significance of this change is that it enables institutions to provide additional scholarships going forward. So offers another type of benefit to student athletes in the future. Next slide, please. So where are we now and what are the collateral issues here? Kind of what's next? Next, the settlement will enter into a multi-step approval process. And this is likely to expand the course of many months. So it's going to take some time for this to all play out. And there are a couple of collateral issues to know, one of which is one that we talked about actually a couple of weeks ago on the program. So there is an open question of whether college athletes are considered university employees. And we've seen this start to play out in the case Johnson versus the NCAA. And it's currently in the process of being resolved by federal courts, such as in Johnson and the NLRB as well. But it's likely for it to take several years for this to work itself out. It's an important question to resolve in the context of this settlement because if athletes are declared employees with collective bargaining rights, according to the settlement, it could be renegotiated. So that definitely has some implications as far as antitrust and as far as payments to student athletes going forward if they are designated collective or employees with collective bargaining power. Also, it's important to note that there's a patchwork of state laws that govern name, image, and likeness, and these laws popped up around the time when Alston was being decided and after Alston as well. And many of these state laws are in conflict with the settlement and with the terms of the settlement. So the NCAA has announced that it plans to use the settlement as leverage with Congress to petition for federal legislation that would preempt these state laws and also shield them from future antitrust suits. So that's also kind of in flux. And then lastly, there is that question of Title IX. It wasn't really discussed in the settlement, and it's important that institutions still ensure that they're complying with Title IX under this settlement. So for example, ensuring that the revenue distribution plan, the 22% distribution plan, complies with Title IX and that scholarships comply with Title IX going forward. Next slide, please. So that's the end of my presentation, and we'll be sure to keep you updated on all of the recent updates in this area, and hopefully we'll have some news with some updates soon. Thank you.
Hey, Paige, a question came in from the audience that I thought was worth your time, if you can answer it. And how would you say that the nearly $3 billion is going to get funded? Is that sorted as yet, or is that to be determined?
It's primarily from the NCAA. There's a specific split between the NCAA and then also the Power 5 conferences. The Power 5 conferences are a much smaller portion, but it's mostly by the NCAA. So yeah, it's a significant amount.
That's great. Thank you so much for highlighting that. And we would love to have you back to keep this group apprised. Let's see if this settlement gets done. As you said, it's really revolutionary, even that it's under discussion. So thank you again. And let's turn then to our next speaker, who is Lauren Schnitzer. As I mentioned, Lauren joined Bond earlier this year. She sits in Melville. We're delighted to have Lauren and several of her colleagues with us. They came over as a school law practice group to augment the group that we have within our Garden City office and to work with our other attorneys around the state. As many of you are aware, school law is a really important part of what we do here at Bond. And Lauren is going to be on the program today for the first time, but we hope certainly not the last. And what Lauren has agreed to cover is some activity here in New York State relating both to safety drills at schools as well as cell phones. So Lauren, without further ado, Lauren, we're really glad to have you and welcome to the program.
Thank you very much. So today we're going to be talking about some changes that have been made to the commissioner's regulations. If we can just go to the next slide, please. There have been amendments to the New York State regulations of the Commissioner of Education regarding school safety plans. There were some that have already taken effect as of July 31st, 2024. And we'll also talk about some changes that are slated to take effect July 1st, 2025, assuming those are adopted at a Board of Regents meeting scheduled to take place in September of 2024. We're also going to touch upon Governor Hochul's consideration that she's been speaking about in public regarding smartphone use in school, particularly her opinion that it is very distracting to our students and distracting them from being able to be attentive and learn. So she is considering legislation regarding smartphone use in school, particularly by our students. Next slide, please. So just for some background, Section 155.17 of the New York State regulations of the Commissioner of Education governs what's called school safety plans. These regulations include requirements that apply to our public schools, our New York State BOCES, and charter schools. And these requirements include the development of confidential building level emergency response plans. These building level response plans mainly address crisis intervention and emergency response and management. These regulations also require district-wide school safety plans. So this would be one document rather than building level documents. And the district-wide school safety plan typically provides critical information to parents, to educators, and to the school community as a whole regarding the school's safety policies and procedures. The building level emergency response plans, those are kept confidential. They cannot be produced to the public. Our district-wide school safety plans are open to the public and really should be shared with the public so everyone understands how our schools are going to be responding to emergencies in a bigger sense. Our building level plans, those include our detailed maps of the building and information that our first responders will have access to. If they're responding to a crisis in the school building, they can see those detailed building plans and floor plans and the more specific information that we want our first responders to see, but would be unsafe to be in the hands of the public. Next slide, please. So the changes to the regulations include a couple of new key requirements. One of the major requirements is a change with respect to the type of emergency drills that schools conduct. So the new requirements provide that if a drill is conducted when students are present, mainly if it's during the school day, or if it's after school, but we have extracurriculars going on, we have sports programs, we have extracurriculars in the building, anytime when students are present in the building, the schools are not allowed, and we must update our plans to provide that we will not be conducting any drills that have props, actors, simulations, or other tactics that are intended to mimic a school shooting or other act of violence or emergency. The way the regulations are drafted and the information from the state is that parents and lawmakers have been speaking out that these realistic active shooter drills that some schools are conducting are traumatizing our students. And they're not really helping to prepare them for a real life event. So rather, the state is now saying when we're conducting a drill, when the students are present, these drills must be conducted in what's called a trauma-informed setting. It must be developmentally and age appropriate. In addition, these drills may only occur after our students and staff have received their annual training in emergency procedures. Next slide, please. The amendments also include additional requirements that the drills must be completed on different dates, different days of the week, and different times of the day. That will help our students and staff become prepared at any time of day or any day of the week in the case of an emergency. Another new crucial requirement is parents or persons in parental relation must be given advance notice of every drill within 1 week before the drill. And at the time a drill is conducted, students and staff must be informed that it is a drill. However, an evacuation drill, we're not going to be informing our students and staff beforehand. That is the one exception. Next slide. The state education department has some materials on their website regarding these drills, and they provide an example. When conducting a drill, we want to make sure we announce over the loudspeaker, this is a drill. This is not an actual emergency. Again, this is a drill. For example, we're now practicing how to do a lockdown. This is a drill. The state is making sure that our students are not traumatized, thinking there's an actual event. They can calm down, they can relax, they can know that this is a drill, this is practice, and this is not an actual emergency. Next slide, please. And the requirements also provide that we can actually seek parental consent to have a student involved in a drill after school hours when there's no other students present, but we can have parental consent to have certain students who have provided consent through their parents to participate in a full-scale drill exercise in conjunction with local and county emergency responders and preparedness officials that include props, actors, simulations, and tactics to mimic a school shooting or other emergency. So again, these types of drills can only have students present if the parents have provided written consent to have their child participate in these kinds of more active shooter, realistic drills. Next slide, please. Unfortunately, these changes are pretty extensive. I'm not going to be able to go through every single change today, but I want everyone listening to understand that there are also new requirements regarding floor plans and area maps that are included in our building level emergency response plans. Particularly, our floor maps and area maps must be clearly labeled and readily understandable for our first responders. And there are a long list of other changes to those items as well in the new regulations. It also includes regulations regarding reporting, evacuation, lockdown, and emergency dismissal drills, and some changes regarding the number of these types of drills to be held every year. Next slide, please. There are additional changes that are in the works regarding safety plans. They are scheduled to be heard by the Board of Regents at their September 2024 meeting. And if they become effective, they'd be effective July 1st, 2025. Next slide. And these proposed amendments would define certain terms that have been confusing in the field. And those terms are listed: evacuate, evacuation, shelter, shelter in place, lockdown, hold in place, secure lockout. These new regulations would define these terms to make sure everyone has a very clear understanding of what they mean, particularly for our first responders. Next slide, please. And finally, just to note for everyone to have an understanding that Governor Hochul is engaged in what she's calling a listening tour She is meeting with educators, parents, and other stakeholders around New York State regarding smartphone use in schools. She has highlighted that she has seen polls and received information that teachers nationwide are saying that students are being distracted by cell phones in class. And she is looking to develop legislation regarding smartphone use in schools, particularly limiting its use in the classroom.
Lauren, thank you so much. A question that came in while you were presenting was about the reach of what you've just walked through concerning safety drills.
Sure.
There was a person wondering, whether this affects individuals, living with intellectual or developmental disabilities, with the concern being that it might not be as easy to partake in drills if living with those differences. How would you respond to that?
Well, the changes in the law regarding school safety plans are really about the drills themselves. These drills have been on the books for years now. If a particular special education class has students that are particularly sensitive to noise, they can address those within the classroom. That's not addressed by the legislation, but certainly schools do take into account our special needs students, and those can be addressed on an individual basis.
Very helpful. Thank you, Lauren. And again, we would love to have you back on a future program and very much appreciate the time you took to digest these issues today.
Thank you.
And with that, let's turn to our third presenter for this program, and that's Michaela Mancini, who sits, I should say, down the hall here in New York City. I've had the pleasure of working with Michaela on a number of matters involving health and litigation. Michaela is a litigator, previously based in Syracuse, and has been based in our New York City office now for some time, and she's been a real boon to all that we do here. We're glad to have her on the webinar today to talk about Title IX. We've had a number of preceding presentations from a variety of attorneys involved in higher education who have been tracking that for us, and Michaela is here to provide us with some updates. Michaela, welcome back, and the floor is yours.
Thank you, Gabe. So yeah, I'm here to talk about Title IX today and kind of the recent updates to regulations and some of the legal landscape that's going on right now. So as some of you may or may not know, Title IX was originally signed in 1972, and it prohibits sex-based discrimination in federally funded education. Since its inception, we've seen constant evolution in the applicability and enforcement of Title IX. And specifically, we see this through these updated regulations that we get from the Department of Education. So most recently, in April of this year, the Department of Education published its most recent changes to the Title IX regulations. And institutions that receive federal funding are required to be in compliance by August 1, which obviously has passed, but there's still time. But these new procedures that will be developed in accordance with these new regulations will only apply to conduct that occurred after August 1. So the policies that were in accordance with the 2020 regulations will apply to any conduct that occurred before August 1. So in addition to the regulations, on July 24th, the Department of Ed published additional guidance to aid institutions in developing these policies. So some key components to note from the new regulations and the guidance that was provided with it is that first, the new regulations included new definitions for certain terms. Most notably, the definition of discrimination on the basis of sex now includes discrimination on the basis of sex stereotypes, sex characteristics, pregnancy or related conditions, sexual orientation, and gender identity. So obviously, this is a more encompassing definition, and this will change policy and procedures as a whole. Second thing is there are now heightened procedural requirements that must be applied when there is a complaint of sex-based harassment involving a student as a party. Some examples of these extra procedural requirements could be written notice of the allegations provided to all parties, providing equal opportunity to access relevant evidence, and an opportunity for each party to have an advisor of their choice. The third thing to note is that institutions are now required to provide supportive measures to complainants and respondents during the grievance procedure or informal resolution process. This could take many different forms, such as excused absences from class, and things like that, but it should be noted that these cannot be unduly burdensome. Fourth thing to note is that institutions should be updating their processes to respond to notice of an employee or a student with a pregnancy-related condition. Some accommodations that should be considered are modifications or break time for employees, modifications for students, and possible lactation spaces that could be provided. And the next thing to note is that if an institution was previously treating individuals differently on the basis of sex in a manner that was permissible under the previous regulations from 2020, institutions should be examining these practices to ensure that they're still permissible under these new 2024 regulations. So a really good example of this is that if an institution operated a sex-separate restroom facility, it cannot now prevent students from accessing that restroom consistent with their gender identity under these new regulations. So that's just a brief overview of these new regulations and what's coming with them. Obviously, this is not a comprehensive list. So you should definitely, if you have any questions about what these regulations require, consult with one of the attorneys in our higher education practice group to ensure that you are compliant. And one more thing that I wanted to note is that you should be aware that there are some federal injunctions across the country that may affect an institution's deadline to comply. I believe that there are injunctions in place in about 26 states right now. New York is not one of them. However, this injunction does apply to a list of 600 schools across the country. So if you have any questions about whether the injunction may apply to your institution, you should direct these questions to someone in Bond's higher education practice group.
Michaela, thank you. That was really informative and keeps us all up to speed. So thank you so much for coming on the program, and we'd love to have you back for a future presentation. With that noted, let's turn to our final speaker for the day, who's going to be Lance Willoughby Hudson. Lance is back on the program. As noted, Lance has been on a fair number of times recently, covering a variety of topics. And we got a question from an audience member, which we try as best to respond to, as I've noted in previous broadcasts. And this time the question was essentially, what's going on with dress codes? We're in an environment where, thank goodness, we've lived through the worst of the pandemic, but there are a variety of norms that have changed in many office places. And the person posing the question was of the impression it would be useful to get an overview. And so Lance is here to provide that for us, just to give us a flavor of, what some of the laws are, the regulations, the statutes, whatever it is that really fits into this space that would be relevant to that question we received. So Lance, thank you so much for taking this time. We're thrilled to have you back on the program and representing the New York City office.
Thank you, Gabe. Hello, everyone. It's good to be back. So like Gabe mentioned, someone did ask a question to us about just dress codes in general. And I'm imagining that the question came up because there's been a lot of changes since 2020, since the COVID-19 pandemic. So between people dressing less formal and working remote, it can be a little in flux as far as what is an appropriate dress code that's legal. Next slide, please. So the first thing to consider when you're looking either to create a dress code or to revise your current dress code is to refer to state, federal, and local discrimination laws. And you want to look at these laws just because they identify certain protected classes of people who are prone to be discriminated against, especially in employment and other areas of life. So the first one that's pretty common and most people know about is the federal law, the Title VII of the Civil Rights Act of 1964. And these are not all the protected classes. These are just some of the ones that are most common when it comes to dress code issues. So the first one is race, color, religion, sex, which includes gender, pregnancy, sexual orientation, and gender identity or national origin. And the other federal law that's more common too when it comes to dress code situations is Americans with Disabilities Act, which covers any individual with like a legit disability as recognized under the law. Next slide, please. And also, you want to look at the state laws as what I mentioned, because state laws and local laws are a little bit more protective and expansive than the federal law. So they just provide a little bit more detail and just expand on what the federal law provides. So for instance, in New York State, discrimination laws are covered under the New York State Human Rights Law. And the New York State Human Rights Law covers the protected areas of gender identity or expression or race, including traits historically associated with race, such as hair texture and protective hairstyles like braids, locks, and twists. Also national origin, including ancestry. And these are just some of the protected areas that are common with dress codes. These are not all the protected classes under the New York State Human Rights Law, but these are the main ones that should be considered for dress codes. Next slide, please. Now we have the local law. And as an example, which is kind of similar to the state law, we have the New York City Human Rights Law. So under the New York City Human Rights Law, some protected classes that are common for dress codes would be gender. And it goes as far as to say, including an individual's actual or perceived sex, an individual's gender identity, self-image, appearance, behavior, or expression. So as you can see, that's a lot more detailed and specific and a little bit more broad too. So it can be kind of interpreted any way if there was some type of issue that arose where someone felt like they were being discriminated against based on their gender. So New York City provides just a little bit more room to interpret that. And I figure I would mention height and weight as well, because these are new protected classes that were just passed in November 2023 that a lot of employers might not consider. And there hasn't been like a lot of litigation on any of these issues yet, but I would not be surprised if something happens down the line just based on employers who might not check their dress code on a regular basis. So just keep that in mind just for New York City employers that you want to look at the height and the weight. Next slide, please. Okay, so next, I'm just going to identify some of the common discrimination claims that stem from dress code policies. So the number one most common protected class is race. So on the federal level, there's the Creating a Respectful and Open World for Natural Hair, which is called the Crown Act. And that basically includes any type of hair texture that's kind of unique to people of color or just any type of religion that has like a specific hairstyle. So that's on the federal level. And there has been instances where some companies have no beard policies, and sometimes no beard policies can be problematic in the sense that, you know, it's part of someone's religion or just someone's culture or their ethnicity to have a beard. There's been a case in the EEOC where I believe this was maybe about 10 years ago where an employer was sued for discriminating against males with beards, and most of the males with beards were African-American men. So the EEOC found that, you know, that beard policy was discriminatory, even though the employer probably wasn't intentionally trying to enforce that beard policy, but the effect of it impacted a lot of Black men. So that's just one example of how a beard policy can be misinterpreted. And one way to get around a policy like this is if a company has like a legitimate business justification for the beard. So for an example, if there's a fire department who has a policy where you can't have a beard because it kind of inhibits the protective gear that's needed to work, that's a legitimate business justification to have a no beard policy. So that's just one example of how you can get around certain situations, but it's all industry specific. So you want to just make sure you kind of know what industry you're in and what policy makes sense for employees and for the employer. The next category that's common as far as discrimination claims would be national origin and religion. Usually this involves just like policies that prohibit like ethnic clothing and clothing or facial hair that's worn in someone's religion. So you want to be careful of that and make sure you have some type of interactive dialogue with the person to see what type of accommodation could be made if they genuinely have a religious belief that requires them to wear a certain garment or have a certain hairstyle. Next slide, please. Okay, and I think this is the most, I wouldn't say most common, but the one that gets a little bit more tricky. So sex and gender. So these examples I have here are just things that you want to stay away from when it comes to implementing dress code policies. So you don't want to put a policy that says women are required to wear skirts, but men are permitted to wear pants. That's just problematic first because you're kind of identifying this gender can wear this item and this gender is allowed to wear this particular item. So you really want to avoid that because that can lead to like litigation and just complaints. And the next thing that can become an issue too is requiring women to wear heels. Although I'm pretty sure this is not as common currently, it has arisen in the past as an issue. So you want to make sure that's not written down in the dress code policy. And something that's a little bit more frequent just based on current trends that are going on in society right now is not allowing men to wear nail polish or makeup. So you want to make sure you don't want to say anything like that. And even if you do have something that's not exactly that wording, but it's the intent is not to have certain people or have employees wear makeup or nail polish, you want to make sure it's justified by a legitimate business reason. Next slide, please. Okay, so just to wrap up everything, first and foremost, one of the best practices is to constantly review federal, state, and local laws and what new laws have been enacted that kind of addresses protective rights for certain classes of protected people. And also too, when you're creating or revising your dress code policy, you want to make sure that it's gender neutral. So you don't want to just isolate men or women in certain type of clothing. You want to just kind of keep it neutral and keep it straightforward. Also too, you want to put language in there that allows for an accommodation. This is really helpful for people with disability or someone who's pregnant or someone who has a religious practice or belief where they have to wear a certain type of garment. You want to just make sure employees have the right to reach out, ask for an accommodation and kind of explain like, hey, I have this disability where I need to wear this certain type of shoe or this certain type of shirt, etc. And for a pregnant employee, you want to just make sure they have the accommodation just to wear maybe clothes that are a little bit more less formal, depending on the nature of the company. So just keep those things in mind as you're drafting dress code policies. And the final thing too, you want to just make sure you have a legitimate business justification for the dress code policy. And I would go farther to say with that, you want to make sure it aligns with the company values and goals. So you just want to make sure you foster something where people feel comfortable and it makes sense that you're implementing this dress code so no one has any need to feel discriminated against.
So Lance, your presentation has prompted a number of really terrific questions from the audience. Unfortunately, we're at time, so we're not going to be able to get to all of them, but let's just take one that was asked by a couple of folks. And so we'll bucket that. It really was about tattoos. How should they be handled? Is there one way to go about tattoos if a employer were inclined to impose certain restrictions, or is that just a place one shouldn't go?
Yeah, so in New York City in particular, there's a new law that was enacted where you can't discriminate against someone based on their tattoos, either an applicant or a current employee. Recently, I revised the handbook where you can put in language where you can permit tattoos as long as it's not like overly distracting or it's not like really exposed. So you can put in language like that, but it all depends really on the industry. you're working in and just kind of the employees and the whole company culture before you put that language in, but you definitely could just kind of tolerate it, but only in certain levels.
Lance, that is helpful. And what I would recommend to anyone listening in, we have lots of attorneys, including Lance, who work on these issues every day for our clients. And so unfortunately, we couldn't get to every question posed. Lance will do his best to respond to those offline. But if you have questions that you see as relating to your business based on this presentation, just please check in with whether Lance or me or with any attorney at Bond with whom you have a working relationship. We want to help you. And so what I also wanted to make sure everybody knew is that we'll continue to take the questions that we get from the audience as we did in this instance. And Lance, thank you for so capably responding to the one that we received. We encourage all of you who are listening to keep them coming. It's what keeps this program topical and otherwise connected to your needs. We did receive a question about whether the slides will be circulated. Indeed, they always are. Anyone who's registered will get them via a link within the next 24 to 48 hours. So look for that. And again, email me if you have any questions or something doesn't get in your inbox as you're expecting. If Kathy, you could go to the next slide, please. Thank you. Here's the list of all of the presenters for today and their email addresses. So feel free to reach out to anyone if you have a question, as I've mentioned. Further, the next time that we'll be going forward with the program is on the 13th of August. I won't be your host, but Kristen Smith will be. I'll be back with you on August 20th, and I really look forward to that. In the interim, if anything does come up, feel free to check in. And we thank you as always for your loyalty to the program and continue to be with us on Tuesdays. We really appreciate it.